For as long as man has been plagued by hunger, disease, and war, his society has also been beset by another peril, malignant and more insidious, the pestilence we call crime. If crime is to be conquered or even held in check, the protectors of society, its law enforcement agencies, must have certain legal procedures at their disposal. One of the most basic of these procedures is the power of search and seizure. This authority is necessary for several reasons: to protect the law enforcement officer from injury or death, to deprive a prisoner of any weapon or instrument of escape, and to prevent his concealing or destroying any evidence that might be used against him at his trial. But the criminal isn't the only one who's likely to destroy evidence. The law enforcement officer may destroy it himself simply by obtaining it in the wrong way and preventing its admission as evidence at all. No matter how guilty a defendant may be, illegally obtained evidence may not be used against him in any court of the land. And so, the police officer's job is more complex than merely obtaining evidence. He must obtain it by lawful means so that it will be acceptable in a court of law and thus support a conviction. Stolen property must be recovered, evidence must be obtained, and criminals be brought to justice, but only by lawful means. The people are assured of their right to privacy and protected from unreasonable searches and seizures by the Fourth Amendment to the Constitution of the United States. This amendment is implemented by Amendment 14, which provides that the individual's right to privacy shall not be abridged by the states, and that no person may be deprived of life, liberty, or property without due process of law. The 14th Amendment also states that all the people are entitled to equal protection under the law. This must be taken to include even those persons who are accused of a crime. The use of illegally obtained evidence would actually supply an incentive to violate the Constitution. And so, for many years, such evidence has been inadmissible in all federal courts. Until 1961, however, many state courts would admit any evidence regardless of how it was obtained. Then, in deciding the case of Mapp versus Ohio, the Supreme Court ruled that evidence obtained by searches and seizures in violation of the Constitution are likewise inadmissible in any state court. This rule, excluding illegally obtained evidence, is now the law of the land. For even if a single American court admitted illegally obtained evidence, then the Fourth Amendment might just as well be stricken from the Constitution. A democratic form of government must obey its own laws, if that government is to survive. The extension of this exclusionary rule to all our courts, rather than giving unfair advantage to the criminal, actually safeguards the people in general, as was the intention of our founding fathers. It protects honest citizens from exploratory searches that are based on suspicion alone. A search is deemed lawful or unlawful from the very beginning. The evidence uncovered by an unlawful search cannot justify the use of improper procedures and make them proper. People lawfully using the highways must not have to submit to the inconvenience and indignity of an unlawful search. The police may not stop every car that comes along just on the chance of finding contraband. No person may be deprived of his right to privacy simply on the chance of finding evidence that may prove him guilty later. This is not due process of law. What makes it difficult for the law enforcement officer is that there's no hard and fast rule to guide him. Reasonable searches are lawful, but whether or not a search is reasonable depends on the individual circumstance. The courts are inclined to allow more leeway in introducing evidence when a serious offense is involved. They tend to be more lenient in the search of a business establishment than of a private dwelling. Nothing is black or white, and the law at present is somewhat fluid. But there are times when a law enforcement officer may be sure of his right to search. In a public place, police officers may seize any contraband that's visible. And of course, whenever a lawful arrest is being made, then a contemporaneous search is well within the bounds of the Constitution. Search, incidental to arrest, is an integral part of law enforcement. A police officer may also conduct a search with the subject's consent, provided that the consent is given voluntarily. If your state or local law provides for the impoundment of cars, any car so impounded may ordinarily be searched. And a search may, of course, be made with a properly obtained search warrant. This is always the preferable method of search and seizure. And we'd live in a virtual police officer's paradise if a search warrant could always be obtained. This, as you know, is not the case. A police officer on patrol is rarely forewarned. And when an emergency situation arises, there simply isn't time to procure a warrant. What empowers a law enforcement officer to conduct an impromptu search in a case like this is a condition termed probable cause. Probable cause does not mean proof of guilt beyond doubt. It means reasonable suspicion, supported by circumstances, but supported strongly enough so that a prudent man would believe that a crime has been committed and that the suspects have committed it. Suspicious circumstances, coupled with evasive answers or attempted flight, is a good example of what generally constitutes probable cause. The police officer must exercise good judgment in each individual case. Suspicion alone is not enough. You must have facts, or there must be circumstances to support that suspicion. It needn't be conclusive evidence. Personal knowledge or reliable information can establish probable cause. But bear in mind that probable cause exists or doesn't exist from the very beginning. Turning up evidence will not establish probable cause if it wasn't there to begin with. In such a case, no evidence you find will be admissible in court. To look at another example, the passing of a slip of paper and a whispered remark may arouse suspicion, but ordinarily this alone is not reasonable grounds for a search, unless the officer has something else to go on as well. A firm reason for believing that this particular slip of paper and whispered remark involved gambling or some other illegal act. When private information is reasonably supported by the officer's own observations, the situation is removed from the realm of pure suspicion. Suspicion plus information plus observation add up to probable cause for searching. Each case must be evaluated on its own merits. But a good general rule of thumb is this. If you told a judge all the facts you know, do you think the judge would then issue a search warrant? If your answer is yes, then you have probable cause. Probable cause gives you the authority to search, provided you act within the accepted limits of the law. We've already mentioned a number of aspects of search and seizure. The first of these, you'll remember, was search with consent. The consent must be free and voluntary. It's important to understand that merely submitting to a police officer's authority or failing to argue with him is no consent at all. Neither do you have valid consent if you've used duress or coercion, either actual or implied. There must be no intimidation whatever. Remember that the incident doesn't end when you conduct your search. You may have to prove in court that the consent for your search was freely given. You cannot base a search on consent by proxy. No one can waive anyone else's constitutional rights. That means that in order to search an apartment, the tenant must give his consent, not the owner or superintendent. Valid consent can be given only by the person who has the actual right to possess the premises. And of course, consent obtained by craft or deception is no consent. You'll have no trouble in court proving that consent was obtained properly if you followed these procedures. Request consent from the legal possessor of the premises, the actual tenant, not the landlord. Inform this person that you wish to conduct a search and tell him why, clearly and unequivocally. The consent he offers must then be positive, clear, and freely given. If your search should produce evidence tending to establish the suspect's guilt, then the court may be very skeptical about the consent being freely given. And so, whenever possible, obtain your consent in writing. Just as there's a right and a wrong way to obtain consent, so are there strict requirements applying to search incidental to arrest. The general principles to follow are these. Visible contraband may be seized before the arrest is made, but the actual search must take place after the arrest. If there's reason to believe that the suspect has contraband hidden in body cavities, these too may be searched, but a doctor should be called to do this searching. If the suspect is carrying anything, you may search it incidental to arrest. You may also search the area and objects within the suspect's immediate reach. If he were sitting at a desk, for example, whose drawer might hold a weapon, the desk drawer is technically included in the person of the suspect. Any of the suspect's possessions that are close to him may also be searched. When you make an arrest such as this away from the suspect's home, the place to take him is back to the station house for booking. You may not accompany him home and search his house. To do that, you'd need a search warrant. However, on arrests that are made in the home of the accused, you may search the premises. In such cases, you'll almost always have an arrest warrant, which, like a search warrant, constitutes due process of law. There should be no deliberate delay in making the arrest once you've obtained the arrest warrant. If he can be taken into custody elsewhere, you may not wait until a suspect comes home, simply so you can arrest him there and thus search his apartment. Only under extenuating circumstances can you delay the arrest. A search of the suspect's home must take place at the time of arrest. Once you've left the premises, you may not return unless you've obtained a search warrant. When an arrest is made in the suspect's home and a search of the premises is conducted, you may seize evidence connected with the crime for which you've made the arrest, and the fruits or instruments of another crime that are apparent. The size of the objects you're seeking limits the scope of your search. If only large articles are involved, you may look only in places where large articles may be hidden. Smaller articles, of course, would allow for the search of drawers and similar small hiding places. There's an exception to the rule about seizing evidence related only to the crime in question. During a valid arrest for breaking and entering, if a search produces lottery slips, narcotics, or other contraband, seizure of these is quite lawful. In any arrest without a warrant, there must be probable cause before you may search. No search of a car may be made simply because a driver has committed a traffic violation. No sham arrest may be made simply to give the police an excuse for exploratory searching. Even if the arrest for a traffic violation is entirely valid, there's no justification to conduct an incidental search of the car. Again, remember that suspicion alone does not constitute probable cause. However, looking into a car from the street is not a search as such. If any contraband is visible, then you have probable cause and reasonable grounds to search. In general, the courts do tend to be a little more lenient about searching vehicles than they are about searching homes. While a vehicle may be moved at any time, a house is going to stay right where it is while you're off obtaining a warrant. And so, where a private dwelling is involved, a search warrant is always desirable. Actually, the law requires that you obtain a search warrant if you have the opportunity to do so. The purpose of a search warrant is to aid in the detection and punishment of crime and to recover stolen property and evidence, while at the same time ensuring the public safety. To avoid any chance of a warrant being attacked later in court, it must conform with certain legal standards. First, of course, it must be issued by a judge or magistrate who is authorized to do so, and it must apply to a location within his territorial jurisdiction. Then, probable cause must exist. This must be supported by statements under oath of the officer who applies for the warrant. Therefore, give every fact you have. It's better to supply too much information than too little. Information given to you by an informer is quite acceptable, but the court must have reasonable faith in its accuracy. If you don't wish to name your informant, at least qualify him by indicating something of his past reliability. To issue the warrant, the court must agree that there are reasonable grounds to believe that a criminal act has taken place or is taking place, and that the search will produce evidence related to it. You must give the address of the place to be searched and a brief description of it. If the building is a rooming house, a hotel, or an apartment house, identify the particular room, apartment, or floor to be searched. The law holds that any search warrant containing indefinite and uncertain descriptions is not due process of law and is unreasonable and void. Name the suspect in possession of the premises to be searched. Using a fictitious name such as John Doe is permissible on a warrant, but it's bad practice. The applying officer would then have to swear that he's made a reasonable effort to find the person's name, but has been unsuccessful. In such cases, a comprehensive description of the person should be given. If the suspect has a known criminal record containing similar violations, say so. It's pertinent. The warrant must include a list of the things you're looking for. No blank spaces may be left in a warrant to be filled in later. This would make it an exploratory search and is not due process. The authorization to search may be directed to a proper officer who is named on the warrant, or it may be directed to an entire class of law enforcement officers. When you execute the warrant, you may bring along another person to identify people or property to be seized. The procedure for executing a warrant is rigid. Inform the person occupying the premises that you have a search warrant and intend to conduct a search. Show him the warrant and gain entrance to the premises. Remember that even though you have a warrant, the search of someone's home is generally a painful experience for the people involved and is apt to arouse intense feeling. Be as considerate as possible, particularly if the suspect's family or other innocent parties are present. However, you may detain anyone on the premises to prevent their removing some article you're looking for. You may even search the person of anyone in the house if you have probable cause to believe that they may be concealing the articles you're looking for. When you search, do it without causing any unnecessary damage. If furniture must be moved, put it back before you leave. In general, disrupt the household as little as possible. Again, your area of search is limited by the size and nature of the articles you're seeking. The property you seize must be the property stated in the warrant or have reasonable relation to it. The same rules apply as with search incidental to arrest. If you turn up what seems to be incriminating evidence, and if it connects to some other crime, you may or may not seize it depending on the circumstance. No warrant authorizes a general search. As we mentioned, in a multiple unit building, the search is confined to that part specifically named or described in the warrant. However, if the person named occupies the whole house, the search may extend to the garage and the entire property generally. The suspect's car, if it's parked adjacent to his dwelling, may be searched as well. You couldn't do this if the suspect's car were parked on a public street outside the property lines. When the search is complete, make a list of the property being seized and give a receipt for it, together with a copy of the search warrant, to the person named on the warrant. Or the receipt and copy of the warrant may be left at the search premises. After the search, a proper return must be made. This simply means turning the warrant back to the issuing judge and giving him an account of everything you've done, showing that you've complied with the mandates of the warrant. Each and every restriction that the law imposes on search and seizure is well-founded. The law has no desire to set criminals free merely because of some irregularity in obtaining evidence. Its intent is to protect the rights of honest citizens. By following lawful procedures, the police officer can be sure that his work will be productive. The evidence he secures will serve in bringing criminals to justice, but without threatening the constitutional rights of any citizen. This is fair all around. The Supreme Court, in ruling on the Map case, summed it up as follows. Our decision, said the court, founded on reason and truth, gives to the individual no more than that which the Constitution guarantees him. To the police officer, no less than that to which honest law enforcement is entitled. And to the courts, that judicial integrity so necessary in the true administration of justice.